Hello, Attorney Prashanthi. I used to
Hello.
work for employer A, and they had to terminate the contract with my client for some reason. So they asked me to find a new employer. I filed an LCA with the new employer, same client, same end client. What if my H1 transfer is denied? Can I find another employer and start the process once again? But what will be my status during this transition? Do I have to go back to India and start the process again?
As they lost their job, the employer A terminated them uh, because their contract with the end client terminated, but the end client is still willing to provide this person with a job as a contractor, but they still need to find an employer to file their H1 and tie all that in. And apparently, they filed an LCA, and unfortunately, the transfer got denied. So the question is, what is the person's status? Now they can only file a transfer, remember, while the person is currently working and they have current pay stubs, or they can use the 60-day grace period rule. As per the 60-day grace period rule, within 60 days of your termination, you can go ahead and file a transfer. Now, if you file the transfer and that period gets over and it gets denied and the 60 days grace period gets over, then you're out of luck. You can still file a H1, presumably transfer again, based
Mhm.
on a nunc-pro-tunc petition, asking on humanitarian grounds for your petition to get approved. Um, but most probably you'd have to go outside the country, get a H1, and come back in so that you don't fall out of status.
So when you said 60-day grace period, right? Now, for example, they filed an extension, the so-called transfer, to another employer while the I-94 is valid. And by the time, God forbid, the H1 transfer extension, the new employer got denied and the I-94 has expired, can they still take advantage of the 60-day grace period?
So the 60-day grace period will start from the last date of employment on the approved H-1B petition, not based on the pending H-1B petition. There is no 60 days grace based on a pending petition. That is just AC 21 rules, which allows you to work based on a pending petition, but it actually doesn't give you any status. So you're not really on a H1 status if you're working on a pending petition. So there's no 60-day grace based on the pending petition. So the only 60-day grace is based on when you left employer A, your H-1B approved petitioner.
So, can you assist our viewers if they get into trouble with the non-protonc petition?
Sure, sure. That is a humanitarian petition based on the non-proton rules, which basically is a humanitarian catch-all kind of rule for all situations. You have to submit affidavits and documentation showing what your situation is and how you had no way of keeping in status, though you tried. So you have to show that it was beyond your control and that you fell out of status due to something that happened that was beyond outside of your control. So based on that, yes, they can sometimes they do approve non-protoncs. The only problem with non-protoncs is we don't know exactly what the processing time is. They sometimes take a few months, sometimes they take 6+ months. So um, and we don't know what the result will be. So it's something to use only if you have no other option.
So, is this something like, appealing a case, or you just write a letter to the immigration attorneys, write a letter to the immigration?
So when we're not filing, it depends on the situation. We could do a nunc-pro-tunc on in an appeal. You can do that together if needed, or you can just file a fresh petition with a nunc-pro-tunc request. So it really depends on the situation.
But I've heard these, if they went for an appeal after denial, the appeals are not processed like, even if a case was originally filed as a premium processing, the appeals take almost a year or sometimes more than a year. So, do you really suggest someone to, unless they don't have an opportunity to refile the case again, do you really recommend someone trying to go and appeal the denied cases?
So it depends on the situation. Again, in some instances, they have to file the appeal. Um, Sometimes they file the appeal to give them additional time to stay back in the country and take care of their affairs. Because while the appeal is pending, you are in status. So that's a key. That's why some people file an appeal. In some instances, say you're filing a BALCA appeal with reference to a PERM petition, they may be filing an appeal because they have to preserve their priority date, the date of filing, because of H1 extension issues or whatever it might be. So in those instances also it makes sense to file a appeal even though BALCA takes 2 years to respond. With the AAO, sometimes it makes sense to file an appeal in an I-485 case, for example, where you see by the face of it they've made a mistake. You file an appeal and they sometimes approve those cases pretty quickly. So if it's a mistake, a mistake which is on the face of it, you can see it's a USCIS mistake, it makes sense to file an appeal. So again, it depends on the situation.
So, how frequent are these USCIS errors or mistakes? We see them a lot, or 1 in 10 cases. What's your experience with this?
It depends on the type of case. I don't see that happening often with the H-1Bs, but it does happen with the 485 cases. They send back the case or they deny the case based on some incorrect grounds, or it could be incorrect due to factually, or it could be incorrect application of the law. So I see this happening more often in 485 cases rather than in H1 cases.
You guys have heard that, as an employer myself, I see a lot of our employees reaching out to us to fill their 485 forms, or they want to do a self filling of forms. I strongly feel it's very dangerous, and your case can be denied and leaving you without status. So you should reach out to attorneys like Prashanthi Reddy to assist with your case. She has 20 years of experience, over 20 years actually, with immigration cases. They work out of the New York office, but then they support clients nationwide, including employers and aspirants or beneficiaries, whoever they are. Thank you for answering that question, Prashanthi.
You're welcome.